The Supreme Court chamber fell into a hushed silence as Elon Musk approached the petitioner's lectern. He adjusted the cuff of his navy blue suit, a rare flicker of unease betraying the usually unflappable tech mogul. Foregoing legal counsel, Musk had made the bold decision to personally argue his company's historic challenge against federal regulatory overreach. Across the bench, Chief Justice John Roberts exchanged a quick glance with Associate Justice Coney Barrett, silent but unmistakably skeptical. The crowded gallery caught every detail. "Mr. Musk," Roberts began, his voice resonant with authority, "you've made the highly unusual choice to represent yourself before this court." A pause. "While that is your right, I must remind you, this is not a tech summit or a social media feed." A ripple of uneasy laughter passed through the gallery. Justice Barrett leaned forward, her tone cool and edged with condescension. "The legal issues before us are extraordinarily nuanced. Are you certain you wouldn't prefer your counsel to speak on your behalf?" Musk remained perfectly still, his face unreadable. He hadn't yet said a word on the merits, but the justices were already working to erode his credibility. What happened next would not only defy those expectations, it would upend decades of legal precedent, leaving even Musk's harshest critics stunned. This wasn't just another eccentric performance from a billionaire. It was about to become one of the most astonishing displays of legal argument the Supreme Court had ever witnessed. Before we dive deeper into this extraordinary courtroom clash, make sure to subscribe and enable notifications for more gripping analyses of today's most significant legal and political battles. Chief Justice John Roberts, 69, had presided over the court for nearly 20 years. Known for his institutional conservatism and careful navigation of a polarized legal system, he carried a reputation for meticulous preparation and an encyclopedic grasp of constitutional law. Rarely had he been caught off guard in his courtroom. Justice Coney Barrett, 52, the youngest member of the bench, had rapidly emerged as an intellectual force. Since her contentious confirmation in 2020, the former Notre Dame law professor had built a reputation for incisive, unforgiving questioning and a strict textualist interpretation of the Constitution. Together, they embodied the weight of America's highest legal authority, an institution that had humbled the nation's most accomplished litigators. Opposing them was Elon Musk, 53, the controversial visionary behind Tesla, SpaceX, and now a major digital speech platform. Renowned for his engineering genius and unpredictable public persona, Musk had shocked the legal world by dismissing his top-tier legal team to personally argue a case with massive implications. The case, Musk vs. Federal Communications Commission, centered on whether recent FCC regulations on content moderation violated constitutional protections. Lower courts had ruled consistently against Musk's company, finding the FCC's actions within its legal scope. The stakes were enormous, billions in potential compliance costs, sweeping operational changes to his platform, and for Musk, a personal reckoning. Critics had long dismissed him as a brilliant engineer but a reckless thinker outside his domain. This was his chance to prove otherwise. "Mr. Musk," Roberts continued, the faintest edge in his voice, "this court's time is not to be taken lightly. I hope your decision to argue personally does not prove a distraction." It was a warning wrapped in formality. The Chief Justice saw Musk's presence as theater, not substance. Justice Barrett added, "Your former counsel's briefs were thorough. What exactly did you find lacking?" It was a trap, inviting Musk to either discredit his own legal team or admit that his appearance was unnecessary. The courtroom held its breath as Musk leaned in and adjusted the microphone. Observers exchanged glances, many bracing for a high-profile flop. What they didn't know, for the past 6 months, Musk had been rigorously preparing for this moment, studying case law, consulting constitutional scholars in secret, and rehearsing arguments with the same obsessive intensity he once brought to rocket engineering. "Thank you, Justice Barrett," Musk began, his voice calm and unexpectedly formal. "I hold my former attorneys in the highest regard. But today's argument isn't just about legal procedure, it's about first principles. about the boundaries of state power in the digital public square. The courtroom froze. This wasn't arrogance, it was something else entirely. My legal team is exceptional, Musk acknowledged. However, this case sits at the crossroads of constitutional law, technological innovation, and the evolving nature of human communication. These are domains where I believe my first-hand experience offers this court a perspective even the most capable attorneys may struggle to convey, because they have not built these systems themselves. Several justices shifted in their seats, caught off guard by Musk's measured tone. This was not the flippant, reactionary figure they had anticipated. There was no bluster, no bravado, only a quiet, surprising authority. Musk continued. The issues before this court today go beyond conventional legal frameworks. They demand an understanding of how content moderation algorithms actually operate, the real-world limitations of artificial intelligence in distinguishing protected from unprotected speech, and the global consequences of American regulatory influence on digital expression. Chief Justice Roberts exchanged a glance with Justice Barrett. This time there was no trace of the smug certainty from earlier, only curiosity, perhaps even a flicker of concern. As Musk methodically arranged his notes, the atmosphere in the courtroom shifted. What had begun as a likely takedown of an overreaching billionaire was slowly morphing into something altogether more uncertain and compelling. Mr. Musk, Roberts said, pivoting to his first line of questioning. Your company argues that the FCC lacks statutory authority to impose these specific content moderation requirements. Yet the Communications Act clearly grants the Commission broad powers to regulate interstate communications. Why should this court carve out a special exemption for your platform? The question was a scalpel, precise, intended to force Musk onto the defensive. Roberts had used this tactic many times before to expose weakness. Musk didn't flinch. Chief Justice Roberts, he began, with respect, I believe the more foundational question is whether the statute, as written, even contemplates what the FCC is attempting. The Communications Act was enacted in 1934, an era when the most advanced communication device was the rotary telephone. While Congress has updated it periodically, the provisions the FCC now relies on were never meant to address algorithmic distribution of user-generated content at global scale. Justice Barrett leaned in, her tone sharp. That's a convenient reading, Mr. Musk. But this court has long recognized that broadly drafted statutes can adapt to new technologies. In Massachusetts versus EPA, we held that the Clean Air Act's definition of air pollutant was expansive enough to include greenhouse gases, even though Congress couldn't have imagined that when drafting it. The courtroom leaned forward. It was a test, a direct challenge to Musk's legal reasoning referencing a complex precedent. Most expected him to falter, but Musk didn't miss a beat. Justice Barrett, I appreciate the citation, and it highlights an important distinction. In Massachusetts versus EPA, the court found that greenhouse gases fit squarely within the statute's original definition of air pollutant. The application was novel, but the regulatory purpose remained faithful to congressional intent. He turned slightly, addressing the entire bench now. By contrast, the FCC's attempt to mandate specific content moderation algorithms represents not just an expanded application, but a fundamental shift. It transforms the agency from a regulator of technical infrastructure into a de facto arbiter of speech. That's not simply interpreting existing authority, it's rewriting the agency's mission, absent clear direction from Congress. Justice Sonia Sotomayor, typically wary of corporate overreach, leaned forward. Mr. Musk, she said, your platform reaches hundreds of millions of Americans. When misinformation spreads on your network, it can impact elections, public health, and even national security. Given those stakes, why shouldn't the government have regulatory authority similar to what it exercises over broadcast media? The question landed with precision, a challenge that had undone many seasoned attorneys before Musk. He took a deliberate pause, gathering his thoughts before responding. Justice Sotomayor, Musk began, his tone steady but firm. That comparison overlooks three critical distinctions. He counted them off. each point delivered with the confidence of someone who had spent months preparing for this moment. First, broadcast spectrum is a limited public resource, which justifies heightened regulation. Digital speech platforms, on the other hand, operate without those physical constraints. He continued. Second, users actively choose to join and engage with digital platforms, whereas broadcast signals enter homes unsolicited. His third point came with a pointed look. And third, the content on my platform is overwhelmingly created by the users, not the platform itself. This makes us more akin to a telephone network than a television station. Musk wasn't just holding his ground. He was dissecting the legal distinctions with an unexpected precision, catching the justices off guard. Justice Neil Gorsuch, known for his skepticism of administrative power, was next to speak. "Even accepting your statutory arguments, Mr. Musk," he asked, his voice steady, "why shouldn't we defer to the FCC's technical expertise in this matter, under Chevron deference principles?" The question ventured into one of the most intricate realms of administrative law, the doctrine of when courts should defer to agency interpretations of ambiguous statutes. It was a point where many would stumble, but Musk's response was swift and direct. "Justice Gorsuch," Musk replied, "I believe this case presents exactly the kind of major question that this court has repeatedly held falls outside Chevron's domain." He didn't hesitate, continuing with a level of assurance that left little room for rebuttal. In West Virginia v. EPA, this court clarified that on matters of vast economic and political significance, we should not assume Congress delegated such authority to an agency without clear, explicit authorization. Musk's words were not merely theoretical, they were grounded in specific legal precedents. He proceeded without notes, speaking from memory. The FCC's proposed regulations would fundamentally alter the way nearly 2 billion people communicate. They would require my company to restructure its core technology and would effectively empower a federal agency to regulate speech that is constitutionally protected. If that doesn't qualify as a major question, I struggle to imagine what would. The justices exchanged glances. This was not the performance they had expected. Barrett, in particular, seemed to be softening. Her skepticism, once palpable, was now replaced by genuine intellectual curiosity. "Mr. Musk," she said, her tone noticeably less dismissive, "your briefs cite Professor Lawrence Lessig's concept of code as law. The idea that software, architecture itself, can regulate behavior as powerfully as legal codes. Could you expand on how that framework applies to the specific regulations at issue here?" It was a sophisticated question, probing not just legal principles but legal theory, designed to test the limits of Musk's preparation. What happened next stunned everyone in the courtroom. Musk stepped slightly back from the podium, his demeanor shifting from defensive to authoritative. His confidence was now unmistakable. "Justice Barrett, I'm glad you raised Professor Lessig's framework because it goes directly to why traditional regulatory approaches fail in the digital world," Musk began, his voice steady, eyes locked on the bench. Without referring to notes, he launched into a nuanced analysis that seamlessly integrated constitutional principles, technological specifics, and regulatory theory. When the FCC mandates specific content moderation algorithms, it isn't just regulating business practices. They are in effect coding law into the very infrastructure of the internet itself. He paused, ensuring the weight of his words landed. "That's a critical distinction," Musk continued. "Because algorithmic regulation operates invisibly, it's continuous. And it occurs without the procedural safeguards that typically accompany traditional law enforcement, like due process or judicial oversight." He quickly pivoted to the specifics of the regulations at hand. Take Section 4B of the regulation, which mandates that platforms reduce the visibility of potentially misleading content. It sounds simple enough, but this requirement forces us to build preemptive filtering systems. And by definition, those systems must restrict speech before determining its actual legal status. Musk's words began to carry the weight of constitutional analysis. This creates a prior restraint problem, something this court has historically scrutinized with the highest level of rigor, starting with Neer v. Minnesota. Unlike traditional regulation, which punishes after a violation, algorithmic mandates censor based on probabilistic judgments. A deep silence fell over the room. Even the most skeptical observers could now see. Musk wasn't reciting rehearsed talking points. He was synthesizing complex legal doctrines with technical expertise in a way that even seasoned Supreme Court advocates rarely managed. Chief Justice Roberts, who had previously displayed a cool condescension, leaned forward. His tone had shifted, no longer dismissive but deeply engaged. "Mr. Musk," he said, "that's a compelling theoretical framework. But let's talk about the practical side. How would you suggest regulating genuine harms, such as coordinated disinformation campaigns by foreign actors without resorting to the algorithmic requirements you're challenging?" It was the kind of question that typically forced advocates into a corner, either retreating to vague principles or conceding. The need for some regulation. Roberts clearly expected Musk to flounder. Instead, the room braced for his next response. Instead of the expected retreat or vagueness, Musk offered something entirely unexpected. A detailed regulatory alternative, one that seemed meticulously crafted to address both government concerns and constitutional constraints. "Chief Justice, I believe there are 3 constitutionally sound approaches that would better address those legitimate concerns," Musk began, his voice steady and resolute. He proceeded to outline a sophisticated regulatory framework involving transparent disclosure requirements, user empowerment tools, and narrowly targeted enforcement against specific illegal content categories. The technical precision was striking, but what truly captured the court's attention was how Musk grounded each of his proposals in existing Supreme Court precedents and statutory authorities. He cited cases and statutory provisions with the ease and depth of a seasoned legal scholar. Justice Barrett, who had been notably skeptical, shifted her approach. She asked a follow-up question that signaled a remarkable turn in her assessment of Musk's arguments. "Your framework is intriguing, Mr. Musk," she began, her tone now more reflective. "It seems to draw on Justice Kennedy's concurrence in Packingham versus North Carolina, regarding the Internet as the modern public square, while also acknowledging the government's interest in preventing specific categories of harm. Have you considered how your approach might be implemented, given the current statutory landscape?" Her question no longer treated Musk as a brash billionaire, but as a serious constitutional thinker. Musk's response showcased not just legal knowledge, but a strategic depth few expected. "Justice Barrett, I believe the existing authorities under Section 5 of the Federal Trade Commission Act already provide a statutory basis for transparency and disclosure requirements. For content-specific regulations, narrowly tailored amendments to Section 230 would be far more appropriate than sweeping FCC rulemaking." He continued with remarkable precision. "This approach would respect the separation of powers by ensuring that Congress, not administrative agencies, is the primary architect of Internet governance, a principle this court emphasized in FDA versus Brown and Williamson Tobacco." What had started as an attempt by Chief Justice Roberts and Justice Barrett to rein in an overconfident billionaire had transformed into one of the most sophisticated constitutional dialogues the court had seen in years. Musk wasn't just holding his ground, he was advancing novel legal frameworks that visibly intrigued the justices. The Solicitor General, representing the FCC, looked increasingly concerned. What should have been a straightforward defense of agency authority had become an uphill battle against a surprisingly formidable opponent. As Musk concluded his arguments, Chief Justice Roberts, now fully engaged with the substance of the issue, asked one final pointed question. "Mr. Musk, given your technical expertise, can you address specifically why the FCC's approach to algorithm regulation is not just legally problematic, but technically flawed?" It was the perfect opening for Musk to merge the legal and technical dimensions of his argument. For the next 4 minutes, he delivered a masterclass on how content moderation algorithms function, the limitations of AI in distinguishing protected from unprotected speech, and why the FCC's mandated approach would inevitably lead to both overblocking legitimate speech and underblocking harmful content. His technical explanation was delivered with such clarity and expertise that even the justices, some with limited technical backgrounds, could grasp the practical problems with the proposed regulation. Musk concluded by tying the technical concerns back to constitutional principles. In essence, the FCC is mandating a technical solution that cannot possibly achieve its stated goals without causing substantial collateral damage to protected speech, the very outcome this court's First Amendment jurisprudence has consistently sought to prevent. As Musk returned to his seat, the courtroom fell silent. The anticipated spectacle of an overconfident billionaire's public humiliation had instead unfolded into a stunning display of legal and technical mastery that had visibly impressed the court. Barrett and Roberts exchanged a final glance, one that conveyed a mutual realization that they had seriously underestimated the man before them. Within hours, legal blogs and news sites were flooded with headlines like "Musk shocks Supreme Court with unexpected legal brilliance" and "Tech billionaire outmaneuvers nation's highest court." Video clips of the most compelling exchanges were shared widely across social media, marking a moment that would be discussed for years to come. Exchanges spread rapidly across social media, with legal experts expressing astonishment at Musk's performance. "I've observed Supreme Court arguments for over 3 decades," commented Harvard law professor Lawrence Tribe on a cable news panel, "and I can say without hesitation that Musk's presentation ranks among the most impressive I've witnessed from a non-attorney. The integration of technical knowledge, constitutional theory, and case law was remarkable." Legal Twitter erupted in analysis from stunned court observers. "The moment Musk cited Justice Kennedy's Packingham concurrence and connected it to Lessig's Coda's law framework was extraordinary," wrote a prominent appellate attorney. "He wasn't just reciting memorized talking points, he was synthesizing complex legal theories in real time." Court insiders reported that during the justices' private conference following the arguments, the discussion had been unusually animated. Although the court's deliberations remained confidential, sources close to several justices indicated that Musk's arguments had significantly influenced the conversation, with multiple justices expressing surprise at the depth of his legal analysis. 3 weeks later, the impact of Musk's performance became even clearer when the court requested supplemental briefing on several of the alternative regulatory frameworks he had proposed. This rare move signaled that the justices were seriously engaging with his suggestions rather than simply deciding the case based on existing arguments. Legal scholars began publishing analyses of Musk's approach to tech regulation, examining how his proposed framework might reshape the relationship between government agencies and digital platforms. Law school professors added the oral argument recording to their constitutional law syllabi as a case study in effective advocacy. For Justices Barrett and Roberts, the experience prompted subtle but meaningful recalibrations in their approach during subsequent technology-related cases. Both demonstrated noticeably more humility when questioning advocates about technical matters. Barrett reportedly told students during a law school visit that the experience had been a valuable reminder that legal expertise comes in many forms, and assumptions about who possesses it can be misleading. Roberts, addressing the American Law Institute several months later, made what many interpreted as an oblique reference to the Musk argument. The bench and bar must increasingly recognize that as technology transforms society, the most valuable legal insights may come from those who understand technology from the inside, not just those trained in traditional legal analysis. For Musk himself, the Supreme Court appearance marked a significant evolution in his public image. While still controversial for his business decisions and social media presence, he had definitively established himself as more than just a technical innovator or wealthy provocateur. Constitutional scholars and legal commentators who had previously dismissed him began engaging seriously with his ideas about technology regulation and digital rights. 6 months after the oral argument, when the court finally issued its ruling, the 7-2 decision largely adopted Musk's position. Justice Barrett, writing for the majority, cited Musk's technical explanations repeatedly and adopted much of his framework for distinguishing between permissible transparency regulations and unconstitutional algorithm mandates. Most significantly, Barrett's opinion concluded with a paragraph that many viewed as a direct acknowledgement of Musk's contribution. As technological innovation continues to transform how Americans exercise their First Amendment rights, courts must be willing to reconsider traditional regulatory frameworks and remain open to insights from those who create and understand these new channels of communication. The complex intersection of code and law demands both legal humility and technical precision. The case would eventually be included in constitutional law textbooks, not just for its substantive holdings, but as a turning point in how courts approached the regulation of digital speech platforms. What had begun as an attempt to humiliate a presumptuous billionaire had instead launched a new chapter in American legal history, one that recognized the need for interdisciplinary approaches to constitutional questions in the digital age. Legal commentators would later identify the case as the beginning of Musk jurisprudence, an approach to technology regulation that emphasized transparency and user choice over government-mandated algorithms and required regulators to work with rather than against the technological realities of digital platforms. For the legal establishment, which had initially dismissed Musk as an amateur, the lesson was clear and humbling. In an era where technology and law increasingly intersect, traditional legal credentials might be necessary but are not sufficient. Sometimes, the most profound legal insights come from those who understand not just what the law says, but how the systems it seeks to regulate actually work.